for having us. We love being here. I have been doing school law for about 12 years, and for almost that entire time I've represented Capel, and so Capel is near and dear to my heart. I'm driving into the admin building today. It's funny, I felt calm driving in here. Most of the time, as lawyers, we're coming into different schools and different places, and you're kind of a little amped up, anxious about some sort of adversarial thing that you're about to handle or deal with. And so it was a feeling of comfort being here today. And as most of you know, if you're around for the Thanksgiving dinner, lunch in this room, I'm always here. So it's great to be here. We really appreciate you being here with us. This is not going to be the most fun presentation we've ever given. It won't be the most fun presentation you've ever attended. Unfortunately, it's just the nature of the subject matter. We will do our best, but very serious stuff. And so I'll let Becca introduce herself.
Hi, I'm Becca Bradley. I know quite a few of you in here, but I won't call you out. I was a middle school teacher prior to going to law school, and then went to law school because it's easier than being a middle school teacher. And then, that's just the reality. And then graduated law school and still wanted to work with educators because I genuinely enjoy educators. It's nice to have clients you like. Not all of my attorney friends get that luxury when they're working with clients. So today we're going to go over sexual harassment statistics. I will tell you this is a growing field of litigation. We are seeing more and more of this. There is no more of, if you ever watched Mad Men, that is like the workplace you cannot have. And so that is what we're trying to avoid. Board policies, you guys have had them for a long time, but let's talk about that evolution in the law and that interpretation. We still will not know a lot of these issues because the Supreme Court has taken up a few more issues. In October, is it 7th or 8th, they're going to hear oral arguments related to transgender and the definition of sex discrimination. So it's evolving quickly. Forms of sexual harassment, believe it or not, there's a lot of different forms of sexual harassment, including same-sex sexual harassment. And the Texas Supreme Court, I always say last year, but it was probably 2 years ago at this point, 2 or 3 years ago, came down with an interesting decision on that. There is a defense when you've been accused of sexual harassment that will talk about unwelcome sexual advances. If you learn nothing else today, generally, if they are unwelcome, they are wrong. So if somebody says, no, please stop, you're done.
So you've all heard recently about the Me Too movement. That's been at the forefront of basically every news story in the past year and a half. And so that's on the forefront of everybody's minds, not just employees, but attorneys and judges, courts all over the country. So there's a hot topic out there. And when there's a hot topic out there, people are more likely to bring those complaints forward. Some valid, some not. Some people are more likely, if they're attorneys, to take on certain cases and to prosecute and to move forward with those cases and cause a lot of angst and litigation and expense to different entities because they have ears that are receptive to these hot button, hot topic issues. There's been pushback now. We're kind of on the backside of the wave of the Me Too movement. There's a lot of pushback at this point in time for false accusations. Accusations that have been made against people that are malicious and not true. What are the rights of the person who's been accused? There's even been some lawsuits where an accused person is going back and suing the person that accused them for those false allegations. So we're seeing not just traditional sexual harassment. It's not just a Mad Men thing. It happens still every day and all over the world. We're seeing the backside of that now, going back towards the alleged victim for a false accusation. So there's just, what I'm trying to say is there's just a lot of issues here right now on this particular topic. That's why we're here. And just bear with us as we go through this. Some of it seems a little like maybe you know this already. Some of it seems kind of far-fetched. But I promise you, all of the stuff in this PowerPoint are exactly questions that Becca and I have answered, lawsuits that we've been involved with, issues that we deal with weekly at least. You wouldn't believe the number of phone calls that we get on this very topic. We're lucky, and y'all are lucky, because we have wonderful, amazing board policy. Board policy is going to be your best friend. It's perfect because all those legal books that are, if you ever come to our office and you come in the front lobby, there's those books with all the numbers on them. Those are all laws and statutes and cases. Well, all those have been condensed down into school law related topics, laws, in your board policy. If you look at your DIA legal policy, that's all of those law books with all the fluff taken out that we don't care about. DIA legal is just school law. You can read that stuff anytime you want and get a really good primer on what this legal issue is about. Then if you want to know how we handle it in the district, look at DIA local. That's how we interpret the law of DIA legal. It's awesome. Not every organization has that. All most places have is just an employee handbook. But we've got two levels. We've got the handbook and we've got the policy. So it's perfect. As I promise you, when I get a call allegedly from Jennifer or Kelly, one of the first things I do is pull up policy.
So when we talk about statistics, the Equal Employment Opportunity Commission in 2018 saw a rise in about 1,500 additional harassment complaints. So they're at about 13,000 out of however many they get a year have been harassment complaints. So when you look at it, 81% of women and 43% of men, we can't leave men out. Men do get sexually harassed. 38% of women reported experienced sexual harassment at their workplace. This was without giving a definition of sexual harassment. So some people may have experienced sexual harassment and have never even known what to call it. Then we have 31% of women and 20% of men who experienced sexual harassment reported feeling anxious or depressed as a result. So it is impacting individuals' mental health. Only 10% of women and 5% of men said they filed an official report to an authority figure. So sexual harassment, when we talk about it, it can be employee to employee. It can also be employee to student. And we've seen that. I will tell you the difficult piece that we're facing now is student to employee. There's not really protection there for that. It's inappropriate, but it's not technically illegal sexual harassment. So we've actually had cases where we had a junior in high school who had this person been a coworker, it would have been sexual harassment for a first-year teacher. Had pinned her up against the wall, had made her very uncomfortable, made a lot of overtures. Even when she said, stop, that's inappropriate. Well, there were really no ramifications other than she had to go to the criminal side and say, is this criminal harassment? So know that there are a lot of dynamics at play with that legally.
Discipline issues, but legal ramifications are a different story when you're dealing with a child to adult sexual harassment, which, as you can imagine, in a school can very likely occur in that situation when you have a 17-year-old student and a 22-year-old teacher.
More than 3 out of 4 women have been verbally harassed in some way. So when we talk about this, do y'all know who that is? Anita Hill. So that's where that was the starting point, right, for this sexual harassment becoming more public, more knowledgeable. And then Chad talked about board policies. This is pulled straight out of your board policies. Harassment on the basis of a protected characteristic is a violation of federal anti-discrimination. So if you are harassed on the basis of a protected characteristic.
Who knows what a protected characteristic is? Any ideas? Mr. Hunt? Just give me one. Age. Age is one. Race is one. Religion is another. National origin, right? Perfect.
Veteran status, genetic non-discrimination, so something genetic. Very interesting. So when we look at it, the question is, what is sex for sex discrimination purposes?
Think like a lawyer, because in laws, right, in statutes, in cases, the way lawyers talk, the way lawyers write, you'll see the word reasonable all the time. If you ask me or Becca a question, it just is habit, we will just say, it depends. That's what lawyers say. Think about when you're reading this stuff, think like a lawyer, and think when they say sex, what does that mean? Does that mean the physical act? Does that mean male, female? Does that mean male to male? What?
So sex has been evolving, and I will tell you there's a split in the courts on what that means right now. So generally, traditionally, sex has been biological sex, male, female, whatever the birth certificate says. Then you have gender stereotypes. So when somebody does not conform to the stereotypical norms of their gender, and they're harassed for it.
I'm a guy from Longview, Texas, but I don't hunt. Do I conform to gender stereotypes for being a guy from East Texas? Probably not.
We were talking to somebody the other day, sweet older lady, who she discriminated against Chad on the basis of his sex by saying that he was not rough and tumble enough because he worked in an office. But it's okay because she said no offense after she said it.
Made me feel better.
Yeah. So, yeah, he's not rough and tumble enough because he works in an office. So that's sex discrimination as we traditionally know it. What we're seeing now is transgender status. You guys have dealt with that with students, employees, whomever. So is transgender status protected under that word sex? And we don't know. The Fifth Circuit has said no, but there are multiple other circuits, the Third Circuit, Seventh Circuit, who have all said, yep, it's protected. So on October 7th, the U.S. Supreme Court is going to hear oral arguments on it, and by the end of the summer, we should know whether that's included or not.
So there's 13 different circuit courts in the United States federal court system. We're in the Fifth Circuit. As you can imagine, each one of those circuits represents different states, different locations. Some are more conservative, some are more liberal with the judges that have been appointed to those areas. So in this particular topic, transgender individuals, transgender status, you can imagine a court in Virginia would rule quite differently than a court in California. And so that's what we have now. That's the recipe for an issue going to the Supreme Court of the United States, because these lower circuit courts have decided something differently. Judges, very, very smart judges on both sides, disagree. And so who is the ultimate authority that can decide this issue? The Supreme Court of the United States. So the issue in controversy, it's a split is what it's called, Rebecca said, in circuits, is now going to the Supreme Court, and we'll have some guidance soon, hopefully. We had pretty good guidance before, and then the new federal government administration came in and has rescinded almost everything. So we're back to the basics for the time being. We're back to the very basic word sex. And what does that mean? We used to have guidance, like I said, the EEOC and different governmental regulations and organizations had issued guidance on what does sex mean, and we could tell you with a pretty clear idea what that meant. When all that got wiped away, we're back to the bare word, and what in the world does it mean? And so that's why we're going to be, and we're up here telling you, probably a little more conservative than you would think in your own personal life, what that word sex means when we talk about gender stereotypes. And that situation that Becca explained, where the nice lady told me I wasn't very rough and tumble because I work in an office, is that sexual harassment, sexual discrimination at this point in time? Probably not, but probably we can't say. And so what are we going to tell you as the people who represent you and want to keep you at all costs out of court and out of the news? Don't do it. It's probably sex discrimination, sexual harassment at this point in time, because we have this split in the circuits, everyone's arguing about it. We don't want to light a match.
So the district has an affirmative duty, which means that you guys have to have your eyes open and be looking around for harassment. So it cannot be one of those things which, oh yeah, I kind of saw that weird exchange, but it was fine. We had an employee that we terminated a couple years ago that was lots of lewd comments. And when I mean lots. When we went back and pulled their internet history, they'd spent more time on the dating website than they did teaching their class. So they'd pull people's pictures up on their dating website and they'd show it to coworkers, like, don't you think this person's attractive? And there were a lot of inappropriate comments like, look at those honkers, that were more graphic than that, and would constantly show coworkers. So it wasn't a comment directed at somebody, but it was a comment that made a lot of people uncomfortable. And it happened over and over and over again. And the principal didn't know. Until one day somebody finally made a comment like in passing, like, oh, I get to be his partner, great. And she was like, well, why don't you want to be his partner? And they said, well, you know, he's kind of dirty. She was like, what? So when it came out and the investigation was done, 25 different people knew about this and nobody said anything. Luckily, the principal didn't know, so their obligation wasn't triggered because they were unaware. But once they knew, they immediately took action and it led to the employee's termination. If you've read the Dallas Morning News, just recently, there was an issue about a school district, a local school district, with an employee being sexually harassed at work. So this is coming up more and more frequent.
When you go back and train the folks that you work with, tell them, say something. Say something. Because it is in your handbook, it is in our policy that if you know about it, you need to tell somebody about it. There's in this point in time in the world, there's no more, well, that's just so-and-so talking. We need to talk about it. We need to tell our supervisor. We need to run it up the chain, right? And we can investigate. We can look into it. It doesn't mean it's an automatic guilty, right? It doesn't mean anything like that. It means we need to know about it and we need to look at it. We have those policies in place, and the DIA local shows the district investigator the steps to take to go down that process, and we'll do it. I mean, we hear this stuff all the time. Unfortunately, Becca and I only hear the bad stuff, not the good stuff that happens everywhere all the time. But you'll get lots of complaints. You'll hear lots of hostile work environment. That's the buzzwords of the day. But hostile work environment is something we need to look into too, because it may be on a protected characteristic, which you remember that previous slide. It may be because I'm wearing a pink tie. Well, that's fine. That's not a protected characteristic. But if it's, we got to drill down a little bit. That's the level of stuff we need to know about, and we need people to tell us about. If this is a hostile work environment, tell somebody.
So what is sexual harassment? It's pretty common sense. Unwelcome sexual advances. Well, that's clearly sexual harassment. Requests for sexual favors. Yeah, how often does that happen? Other verbal or physical conduct of a sexual nature, submission to which is a term or condition of a person's exercise or enjoyment of any right, privilege, power, or immunity, either explicitly or implicitly. That's usually where we catch folks. That implicit, well, I never told them that they had to do this to get a promotion. Well, it was implied. So there was, and in fact, we think this doesn't happen anymore. Our office is actually conducting an investigation for a district right now where this person has a history, 15 years, had been at multiple districts and had bounced around. Come to find out, this person had allegations at every district, but would move on before they were sustained, or the victim would say, oh, I don't want to talk about it, and then we'd end up in a position where this person is pretty high ranking and has done this repeatedly. And like conditioned a promotion, like said, if you don't make out with me, you're not going to get promoted. Like very blatant violations. So when you do this, you've got to be very careful. When you receive a report and that person says, oh, but I don't want anything to happen with this, that's not a choice at that point. They can choose down the road not to write a statement, not to do that, but you have an obligation to report it up the chain. So there's no more this, but they didn't want me to investigate it, and 6 months down the road they said, why didn't you take care of it? It's your obligation to go ahead and take care of it. The other piece of that is don't forget to do something right now. So you report it, and you have to put something in place right now to protect that individual. So we had a situation where 2 employees worked together. Their kids played on the same baseball team. Well, one of the employees was having an affair with the other employee's husband. Well, the mistress was very upset because the wife wouldn't talk to her at school once it came out. Kid you not. She then was trying to engage the wife at school repeatedly, and the wife finally said, you're harassing me, stop. And then, ironically, the mistress filed a grievance against the wife for telling her to stop. I mean, you can't make this stuff up. And so at one point, the poor HR director looked at the mistress and said, what did you think was gonna happen? And then the husband got involved and it just mushroomed in a big way.
He was involved. So let's go real quick, Becca. Like, okay, so hypothetical, what do we do in this situation? I'm talking to Jennifer, and I say, Jennifer Valines and I are talking, and you overhear that I'm telling Jennifer that Kelly is making inappropriate comments to me. You overhear that. You're not a part of me and Jennifer's conversation about Kelly, but then you hear it. What do you do as an employee of Capella ISD?
You go and inform the supervisor immediately. So you guys will be receiving that information, and then the supervisor needs to take immediate action to separate the two employees while you conduct the investigation.
I'm the victim. Kelly is the perpetrator, allegedly.
Sorry, Kelly.
And so if you're going to take some sort of interim action, which is necessary and required to protect the victim, are you going to move me to a different location? Or are you going to reassign me?
Nope. You're going to reassign the alleged perpetrator. And it may be temporary. So it may just be, hey, perpetrator, you can't be in the lunchroom at the same time. We're going to have you on different duties. We're going to do all of that.
Okay, so now I come to you and I say, oh my gosh, you're an employee of the district, and oh my gosh, Kelly is totally making me feel weird. What's going on? I don't know what to do about it. And so I'm just telling you about it, but oh my, I'm not going to do anything about it. I'm not going to tell anyone. I'm not going to write a statement. I'm not going to do anything. I'm just have to get this off my chest because I feel weird.
Yeah, you go and report to somebody, and you encourage the employee to report. Let's go talk to the supervisor together. Let's go make that report. There's no more, oh, no, it wasn't a big deal. Where we've seen it, we've unfortunately seen it where somebody says, I don't want to report that right now, and it escalates. And then it's too late. Something really bad happens, like a sexual assault. And had the district known back when it first was stated to somebody else, it would have been taken care of and they never would have been put in that position.
So Kristen's assigned as the investigator. She comes and talks to me, the victim, and I'm like, I'm not saying a word. I don't want to talk about it at all. And I'm not saying anything, just not writing anything. I don't know. Does Kristen still have to finish the investigation and do everything and close it all out and maybe take different action?
Yes, so there is a provision that says even if all allegations were proven true, it wouldn't constitute sexual harassment. You don't have to investigate that. So when somebody says, they hurt my feelings because I'm tall, well, that's not a protected characteristic. That's not necessarily illegal harassment. I still am probably going to look into it and take appropriate action, which may just be, hey, don't comment on the person's height. If it is something where the victim's saying, I don't want to be involved, okay, we understand that, and we'll try to maintain confidentiality to the maximum extent, but we're going to go look into it. And generally where there's smoke, there's fire. I'm just telling you. So if somebody can't articulate what's weird, they say, this person makes me feel uncomfortable, I can't really put my finger on it, there's generally something there. Not always, let's be very clear. We also, Chad and I did a sexual harassment training, and it was the weirdest thing I've ever seen. We were sitting in the training, and literally it became testimonials of those falsely accused, where different individuals started standing up because we were taking questions from the audience. That was a mistake. And there were like 4 different people who stood up and said, I too have been falsely accused.
Literally, that was the quote, and with real tears.
Wow. And we were like, what is going on? And then they shared what they were accused of in a room full of 300 people. Their bosses didn't even know they had been previously accused.
The first time they said I hit my wife was not true.
Yeah. And I got kicked
Okay.
And I got kicked out of my church, and and one of them said something that was new that nobody had heard of. Well, this student said that I harassed him for a grade. Hold on. So that person just said this to a room full of 300 people. Nobody knew that that was an allegation made against them. Guess what they have to do? They have to go investigate. investigated. So it got real weird.
The bottom line here is what we're trying to hopefully get across is when you hear those words, hostile work environment, discrimination, harassment, we need to find out whether or not, we need to look into it as quickly as we need to take interim action, protect the victim, look into it as quickly as we can, whether that's through a statement to the person who is from the alleged victim, or a statement from the other person who's the perpetrator, whatever, to figure out, number one, is it because of a protected characteristic? If it is, we're going to go on down the road. If we've got documentation in place already from our statements, from going to talk to people, that it's not a protected characteristic, it's about the color of my tie or my height or some other unprotected issue, well then we're kind of relaxed a little bit at that point. But the point is, we need to take everything very seriously right now in this sort of legal climate and find out, first and foremost, in writing with documentation, is your hostile work environment, is your weirdness feelings, whatever it may be, based on protected characteristics, age, sex, national origin, race, religion.
So when we talk about this, a lot of times, and we'll get there a little bit in more detail, same-sex sexual harassment is overlooked. Like, oh, we were just two guys talking about it. Like it was, I cannot tell you how many times I've heard the quote, it was locker room talk. Well, that doesn't work anymore. Where you could get away with that 50 years ago, that's not how we operate now. And some of the most crass things I've ever heard have come out of females' mouths. I'm just gonna be honest, about a man that they work with. So we've seen it both ways. Please do not feel like this is an attack on guys in any way. We've seen it go both ways, and we've seen it same sex and opposite sex. So conversations of a sexual nature. Be careful of your coworkers or your friends, and you may share personal, intimate details with them. Some people may think that they're friends with their coworkers and share personal, intimate details that friend does not want to hear. So we had an employee who was dating a boyfriend who had sent some nudes to her. She's like, look at my new boyfriend. And she's like showing off the pictures in the lounge. Yeah. That made people real uncomfortable. So she was reported, and it ended up being sexual harassment because she was engaging in these explicit conversations in the lounge.
We won't bore you to death with war stories, but tell them the Ryan Gosling one, just to talk about the levels of ridiculousness that we do have to look at and investigate.
So an employee, first year teacher, male teacher, was upset because he was the only male teacher on his campus, and it was an elementary school campus, and in the break room where the copier was, it had a giant Ryan Gosling poster with like his shirt, and this was his description, unbuttoned to his navel. That was the description that I had gotten of the Ryan Gosling. And it just said, hey girl, put more paper in the copier when you're done. Very offended by the Ryan Gosling. And so I kid you not, we went all the way to the board with a complaint of sexual harassment about this Ryan Gosling poster.
What do you do? Is it based on a protected characteristic that he's claiming?
No.
Because he's a male, right?
And so he felt discriminated against and uncomfortable with the sexualized image of Ryan Gosling. So we hear things like that, and then we hear the more egregious, this person assaulted me in some way. So just be aware that all of them are taken with equal consideration and investigations are conducted. You're going to go through your process, even if in the end it looks very different with the outcome. So encourage folks to report. This day of being worried about grievances and reporting and filing, no, that gives the district an opportunity to resolve whatever the issue is. So encourage folks to report. And then make sure that they report to, don't require them to report to a certain person. We've had it in the past where like a principal, they may not feel comfortable with the principal, but they may feel comfortable with Kelly because Kelly and this person worked together 15 years ago. And so they go straight to Kelly, skipping over the principal. We've had principals go back, and it's been litigated, where they say you should have directly talked to me first. You should have taken it up the chain of command. Well, if they're saying I feel harassed and they feel more comfortable taking it to Kelly, let's not write them up because they didn't bring it to you. That is where we've got some campus administrators in big trouble. It's because they were offended. Or the employee won't say anything to anybody and then they'll send an email to Brad Hunt. And then that gets passed back down, obviously, to go through the appropriate channels. But if that's what that employee feels comfortable doing, don't go back and write them up or reprimand them for not going that route.
When we work for a governmental entity, there is a constitutional provision in the state constitution that says anyone, employees, students, Joe you-know-who off the street, can file a grievance and redress their grievances before the board. It doesn't say can only file a grievance about this or that. They can go to the board, they as an employee, students, general people out there in the community, for anything. We have a policy, we have a procedure in place to kind of go through those complaints and process them and give people the appropriate due process. But we can't discourage people, especially on this sort of an issue, like Becca was saying, from not reporting, not filing a grievance. Never ever do that, please. It's a constitutional right. We'll lose that every time, unfortunately, if we try to tell people, you can't file a grievance on this, or you can't talk to me about this, or you should have talked to me instead of so-and-so about this.
What happens if an employee says, I want to file criminal charges? What is the appropriate response? That is your right. If you would like me to contact law enforcement and have them come meet you, that's fine. Same with students. At no point do you ever want to be seen discouraging that. What if they say, I want to file an EEOC complaint? Again, that is your right. Go for it. Who is the district's Title IX coordinator? Yes, please make sure she's looped in, especially if it involves students, but not just for students. Jennifer needs to know if there's a sexual harassment, sexual violence, sexual discrimination claim in general. Jennifer and Kelly work together pretty closely when it comes to something like that.
You've all been probably trained to death on Title IX, but in the void of guidance, legal guidance right now that we're living in, the first line of Title IX, the law says, shall not discriminate based upon sex. It's not just athletics. In this world, in this current climate, it means, we used to have guidance, we don't now, it means everything. So everything based upon sex, all the stuff that Becca's already talked about, needs to be also looped in with Jennifer.
And then if somebody wants to make a complaint against Jennifer as the Title IX coordinator, or whoever your Title IX coordinator is in the future, they send that directly to Mr. Hunt. If they're making complaints about Mr. Hunt, they send that to the board. So everybody has a complaint process. Nobody is above receiving a complaint against them. We just want to make that very clear. And then timely reporting. Please encourage folks to report as quickly as possible. The longer the gap, the harder it becomes. So the investigation we're doing in our office, it took 14 months for the individual employee to feel comfortable in reporting it. So 14 months, now we're trying to go back and pull witnesses and figure out what happened that night. Also, I will just tell you, y'all, Christmas parties and alcohol, it's where we get the most of our complaints. We will get them, literally people are going for winter break and they've had some sort of holiday party and somebody drank too much and got a little handsy. I mean, that's just the reality of it. And so we can almost put a stopwatch on it that, okay, we know these people are having their party this day, this is when we're gonna get the call.
And more importantly here, because I like Christmas parties, what do you do when you go back and you're doing your training and you're talking to your folks and you're talking about the same stuff and you're referencing what we talked about, and we get to this part about report as soon as you can. Timeliness matters. But you will probably have one point in your careers here, and probably after you do this training, the employee will come to you and say, 6 years ago, I was on campus and this happened to me. Do we still have to look into that? 6 years ago. It's almost impossible to do, but we need to look into it, is the answer. I can almost guarantee you, when you go back and you talk about this with your folks, you will hear a lot of stuff that you never imagined. at least some of you. And if that sort of situation comes up, it is 6 years ago, and even if one of those parties is still gone, or is gone, not still gone, but gone, I mean, we don't have any subpoena power. We can't go get that person that's now, in South Texas or whatever, but we can certainly do an investigation on what we have here. And that's kind of the baseline for all of this stuff, is we have to look into it with whatever we have available and however we can.
So when we look at that hostile work environment, there's definitions for every definition, right, in the law, and so this is one of those definitions. It's verbal or physical, so it can be either one. It can also be written, just so you know. The law has been expanded to include that written piece. So we've had employees who write fan fiction about a coworker, like 50 Shades of Grey type fan fiction. That's going to get you there, even if you didn't read it out loud. Based on a person's sex, race, color, religion, or national origin, has the purpose of creating an intimidating, hostile, or offensive work environment. That's based on a reasonable person's standard. Would a reasonable person coming into this situation find that conduct offensive? So that individual person, because there's levels of sensitivity, right? So some people may get there really quickly, some people may never get there as far as offensiveness. And so we have to look at it, what is the reasonable, objective person coming in thinking it? Has the purpose of or effect of unreasonably interfering with an individual's work or performance. So if somebody has to start taking a different way to their classroom because they're avoiding a teacher, if somebody has to park in a different parking lot, if they start calling in, where we see it most often is somebody starts calling in regularly because they don't want to work with somebody, or they have anxiety, they need to take breaks, or it otherwise adversely affects an individual's employment opportunities. If they don't get to go to a PTA brunch where they were going to be honored because this other person is going to be there, that's a problem. This is just so you know, sort of the landmark case here was a banking case. The bank president had a relationship with a subordinate, a bank teller, and she felt like she was obligated to enter into that sexual relationship because it was the bank president asking for her. 2 years this relationship went on, and she said it was unwelcome every time. I didn't want to, but I felt like I had to because he was my boss. And the Supreme Court said, yeah, that's a pretty good standard. So just know if you supervise somebody, it's even more so, because what you can get into is the quid pro quo. We like to call this the old school sexual harassment. It's conditioning something in the workplace on a sexual favor, sexual advance, sexual comments, all of those things. That's the classic way of thinking of sexual harassment.
Anytime you have a supervisor-subordinate situation, no matter the sexes involved, male, female, on either side, whatever, all male, all female, anytime there's a subordinate supervisor issue, it's just assumed, honestly, that it's quid pro quo. It just is. That's almost impossible to prove when you get to a court of law that it wasn't this for that, something for something, when you have that sort of a situation. So if you ever hear that, someone ever reports something to you and you hear those, well, that's my boss or that's her boss or his boss, that should be like giant alarm bells.
And it doesn't even have to be the legitimate supervisor if they have the appearance of being over that person. So if we have an instructional coach who technically is not a supervisor to that teacher, but they're sent in to help that teacher with instruction, it's still going to have that appearance of having that ability to supervise that person. It doesn't necessarily just comply with the organizational chart. So quid pro quo and hostile work environment are the two different claims. They're very similar. They're hard to parse out. Just to be quite honest, it's hard to pull them and separate them. It doesn't really matter. It's all sexual harassment. So when we get there, most of the threats that we see for quid pro quo or hostile work environment are implicit. So they may not come directly out and send a text message that says you have to do this for this. So when we look at retaliatory discharge, so if somebody says, I don't want this to happen anymore, and they feel like they have no other option but to leave, we've just constructively discharged them, which is illegal. We've made the work environment so horrible that this person has no other option but to leave.
We've allowed the work environment to be so.
So be aware of that. Those climate surveys that you guys do on occasion, those are crucial, because if we start getting reports back in those, we're gonna have to look at it. Are we constructively discharging our employees? Which is why that relationship piece becomes so important. You wanna have that trust for them to come in and speak to you. Be careful, draw the line in the sand when it comes to relationships. Don't cross that line with students or with coworkers, because you wanna be very careful. This is work, this is not work.
So how does it work, Becca, when, let's just continue with my bad example of I'm complaining about some actions that Kelly has taken towards me, and now the investigator is Kristen, and Kristen has gone through and she's gotten statements from everyone, and Kristen's determined that it's on a protected characteristic, it's based upon me being a male, and we get to the part where we have to look at, under DIA legal and local, did it unreasonably interfere with my work environment, so on and so forth. How do you determine that in the school district? And what if someone disagrees? Maybe the next person in the grievance process or the board? I mean, how does a district investigator know that? What unreasonably interferes with my work environment?
So again, that's that reasonable person objective standard. And so you look at what would a reasonable person think this is doing. Would they feel like because employees will generally say, I've had to do this, I've had to go to therapy, I've had to get medication for anxiety, I've had all these different issues. I haven't been able to come to work as often. Those would all be considered unreasonably interfering. So you have to look at what changed for this employee. And let's be clear, just because something may not be sexual harassment does not mean it's not still prohibited conduct. Something may be a prohibited conduct violation under the Educator Code of Ethics or something else without being sexual harassment. So even when you get to the end of it and you say no sexual harassment, it doesn't mean there won't be some sort of action taken or that employee did not do something wrong. So what we've seen is like an off-the-cuff comment that's offensive to somebody that gets reported. Well, it probably is not severe pervasive enough to unreasonably interfere, but that doesn't mean that comment should have ever been made in the workplace. So we're going to give directives and training to approach that and have that conversation.
So Kristen, part of the investigation, I told Kristen that, I still have to work with Kelly, and it's fine, I just don't really want to sit next to her when we go to Christina. That's about it. And so Kristen found that doesn't unreasonably interfere with my work environment. It's not severe or pervasive. Can I go back and sue Kristen because she didn't think that was me as the employee?
No. So that's one of the great things, is if you follow your process, the determination doesn't really matter from the legal standpoint. So as long as it's supported by the evidence, it's not something like everything is showing sexual harassment and you're like, no, but that's a good person. It's fine, I've known them since we were 3. As long as the evidence can somewhat support what you're saying, you are fine. And you followed your process, it doesn't really matter that the employee disagrees with you. You're going to be protected. It's when you don't follow the process that you're going to get in trouble.
So you're immune, the word immune, from suit as district employees as long as you are acting within the course and scope of your duties. Okay? That's a pretty wide latitude, very wide, very easy to retain your immunity. Simple to retain your immunity. Becca, be our example. How do you lose immunity? By turning your back and saying, I'm deliberately indifferent. I heard about this sexual harassment and I don't care, I didn't look into it, I didn't tell anybody, I didn't investigate it. So that's how you lose your immunity, is by hearing it, knowing about it, and doing absolutely nothing. That's being deliberately indifferent. Just between us friends here, if you do just about anything, you don't have to be an FBI investigator. You don't have to turn over the files in the workroom to find that little shred of evidence that may be there. You've got to just do something, and you're not deliberately indifferent.
And
That's it.
document that you did something, because people forget. Document that you did something. So the phrase is always screenshot or it didn't happen. Like my husband and I think some of you have heard this, play slug bug because we're children in the car, and we're hyper competitive about it. And so we'll be walking into the mall and we'll see a VW bug and we'll say slug bug black, no hitbacks. Like we do the really intense game. And so we'll walk into the mall, fine, we'll come back out, and my husband tries to do it again. And I'm like, no, you cheat, that's the same car. And he turns to me indignantly and says, screenshot or it didn't happen. You don't know for a fact that that's the same car. By the way, guys, he's the pastor here. So he's the pastor, I'm the lawyer, and that's his response. So, and it's like that very much in litigation, in our documentation. If EEOC comes in or OCR comes in, it's if you don't have it down on paper, how do we know that it actually happened? It's that screenshot or it didn't happen moment for you guys. And so to the extent you can send an email to somebody and say, hey, this is what we've done. Here's the actions we've put into place.
Here's the statements I received.
Mm-hmm. There was just a case on gender stereotyping, Price Waterhouse, and it was a woman who said that she was denied partnership at her firm because she was not feminine enough. She was actually told that she needed to walk more femininely, talk more femininely, dress more femininely, wear makeup, have her hair styled, and wear jewelry. She was told that by a partner. Yeah, that's going to be gender stereotyping, sexual harassment. And again, we think it doesn't happen. I went to an interview with an attorney who was fantastic, and she told me, you don't work with me unless you wear skirts and pantyhose every day. And I said, I don't know that this is a good fit. Because that was how she came up. She said, we're in a male-dominated field. You need to be a powerful woman. Here's how you look like a powerful woman. That was her perception. She's mellowed over the years to that perception, but that was, she said that in an interview with me. So talk about problematic sexual harassment. So be careful. Also be careful what you say in interviews. Please don't ask anybody about their children. If they plan to have children, if they're married, don't ask them about what church they may attend. If they volunteer that information, totally fine. But you have to be very careful not to ask those harassing questions, because then if they don't get the job, the argument's going to be, you discriminated against me on the basis of my sex, my gender stereotyping, whatever the case may be. So be very careful in interviews when you're meeting with teachers. It seems like your guys are just having a rapport, you're just trying to make a connection, and then you get a lawsuit.
And I know you guys are thinking, oh my gosh, I can't say anything, I can't do anything. What in the heck am I supposed to do in the current world? I can't talk about anything. And we're lawyers, we're up here talking about a perfect world. No one's perfect. Things happen in the world. But these are things that we hear, arguments that we hear from the other side, from people who don't get the job, or from people who have been reassigned and they don't agree with it. They're just, their role, their job is to poke holes in things and to bring up arguments. And we hear these arguments of, well, you asked me about my children. Well, I felt weird around him or her, and that's why you're reassigning me, because you're, you know, those are arguments. It doesn't mean the district has done something wrong. It doesn't mean you've done something wrong. But these arguments are something, as lawyers, we like to limit risk, right? And so just these little things that we talk about today, you're not going to remember every single thing, but to the extent you do remember some of the stuff, it will ring bells in your head, and you will remember to look at DIA, local, and legal. You'll remember, that's not what I'm supposed to do, or this is what I should do now. And that sort of little action changes the course of an event drastically. If we can change that trajectory just a tiny little bit when they're talking to you all, and we take the right couple of steps in the beginning, we end up with a problem that's fixed at the campus or here at admin really simply, or we can possibly end up with a problem that goes before the board. And so that's the true value in these kind of trainings. not to be overly, draconian about what we're talking about. We get it. We understand that this is perfect world, what we're talking about. Real things happen. Our law firm is not, the best example. I've been in interviews with some of the older attorneys. It's not just older people, but in this case it was an older partner who just straight up said to a law school graduate, wow, you're from, you went to Austin College. I didn't know they had pretty girls there. That kind of stuff. It happens. It happens.
Yeah.
But
To be fair, they were also an alumni.
yeah.
So.
But remember, we're trying to limit risk, we're trying to limit arguments, and this is just a scary point in time in the world with where we're at in law on this topic.
So same-sex sexual harassment, it exists. There's no longer that argument of, oh, well, they were both women, or they were both men, and it was locker room talk. The seminal case for this is the Sundowner Offshore Services. They were on an oil rig, majority men, and it was that locker room talk, except that this man happened to be a little more feminine, and so he got made fun of for that. And the Supreme Court said, yep, sexual harassment, that's going to do it. It doesn't matter that they're of the same biological sex. The Texas Supreme Court 2 years ago decided a case that was really interesting because it added nuance to this. It's really egregious, like just, I don't know how to say it nicer. This woman just had a filthy mouth. The things the quotes that she was cited as saying are like, they make you blush when you're reading them in print. And the lawyer's having to say this in court, and I'm just thinking, oh gosh, this is not for me.
Which you could totally do, I couldn't do.
Yeah, what's funny is people will call with things, and I grew up with like a nurse, and my mom was just very technical, and there was just not a whole lot of like, oh, that's a little embarrassing. Like my mom didn't have that embarrassment threshold. So people will call and they'll be like male clients, is Chad available? And I'm like, what do you mean? And they're like, well, I've got something that's sexual. Okay, yeah, let me get Chad. I go get Chad because that's what they think they're going to feel more comfortable with. Poor Chad blushes the entire phone call. Little do they know, I'm probably the one that could just be very like, oh, okay, technical about it. And Chad's the one that gets like, oh, cool. So, same-sex sexual, she was making a coworker very uncomfortable, and the coworker actually ended up suing the employee because she was like just a level above. Sued the company said, this isn't sexual harassment, it was not sexually motivated conduct. Just because she was showing nudes of her different sexual partners to this other woman doesn't mean it was sexually motivated towards that other woman. So the Texas Supreme Court actually sort of, where the offshore services case made it, yes, it's protected. The Texas Supreme Court then came in and said, well, is it? It's protected if it's meant to be sexually motivated. So if you have two heterosexual women who one is just being dirty, but not actually trying to engage in a sexual relationship with the other person, then it is not necessarily sexual harassment. For purposes of, if that's where we're at, it's probably going to be sexual harassment. That was a very specific instance, but it did sort of throw everybody into a, whoa, what does this look like now?
Us good Baylor kids, Kristen, have never heard such things.
Of course we have not. Never ever.
Yeah.
So the court has also said, look, we don't expect the workplace to be asexual. We don't expect it to be androgynous. Like, we understand that there are certain things that are going to be sexual comments or on the basis of sex. Like, we just know that's going to happen in a workplace. That's just sort of natural. We don't expect that. But when it starts to interfere with somebody else's work is when it becomes a problem.
Which is really interesting. I mean, if you're a nerd lawyer, I guess, it was courts attempting to, and judges attempting to be reasonable. And so there is some value there for us regular folks too, that, if it affects, if what you're doing substantially reasonably interferes with somebody else, then that's a problem. And so, yeah, there's going to be comments made all the time. Becca enjoys making them in my office because I turn red. There's going to be comments all the time that happen in the workplace. But if it interferes with someone else, not yourself, not your friends that are involved that talk about this kind of stuff, someone else, that's when we need to be concerned with it, and that's when maybe you start thinking about, okay, is this something I have to report? Like I said, we're in a strange time in the world. If you feel it in your gut, is this something I need to report? You need to report it.
So here's a defense for sexual harassment claims. There was no adverse employment action taken. There was no interference with their job. The other piece that's going to be most important for you guys is that the employer took reasonable care. Once it was reported, they took the action in accordance with policy. That's the biggest piece for you guys. Follow policy. So in looking at that, your policy has some major steps, right? So the first is report it to the right person. Check. That's the easy one. We report it, then comes the investigation piece of it. During the investigation, there needs to be some sort of interim action put in place. So what actions need to be taken to protect the people involved while we are looking into it? Once the investigation is completed, a findings letter needs to be issued. We give our findings and our final report, and then we take whatever action is necessary. That's your general process. It's all written down in DIA local for you guys. What's our first step on our investigation? Who do we need to talk to? Yeah, let's talk to the whole team. Just having a verbal conversation, is that all we need to do? No, have them write their own statements, date and sign them, please. All statements need to be dated and signed, because if something changes overnight and they come back, we need to know that if they think of something else. We also want it to be in their own words. We're not gonna assume that we understand what you mean. We want you to write what you mean.
If I wrote in my statement, oh, Dr. Jund was also there, do you need to go talk to Dr. Jund?
Yes. Follow the rabbit trails that come up. If somebody mentions a text message, great, can you share that with me? If they do not be afraid to pull somebody's email history. So if they say, or their web history, if that's where you are, if they said, I've walked in and I've seen this person watching porn during their planning period, somebody needs to be contacting IT to get that internet history pulled. So just follow all the rabbit trails.
There's no expectation of privacy in any of your work-related documents, information, data storage devices, desks, anything. So if there's something like that, where time is of the essence and you need to find out what's really going on, get Kelly involved and get it done real quick, because we don't need, despite what some employees will say, you don't need a warrant to go search their desk. You don't need a warrant to sniff the bottle that's on their water that's on their desk. Right? You don't need a warrant to find out every single email they've ever sent from their CISD address. We can get that quickly.
So let's say you're interviewing the individual, the male that's being called the pedo. And he says, yeah, actually this has happened several times, including one at a PTA mixer, and these 4 parents were there. What do we do? Do we go interview those parents? Yes. Yep, if parents say, no, I don't want to be a part of this, totally fine, we understand and we respect that. But did you witness anything strange? Were you uncomfortable by any of this? And so just be aware that once you do that, that may cause a firestorm. Make sure that other folks are involved before you go there. So, because that PTA mom's going to go to other PTA moms and say, oh my gosh, listen to this drama. And then everybody's going to know about it, and you're there. So let's say everybody says, yeah, she calls him pedo. In fact, one of the moms said, we thought his name was Pete, and it was a cute nickname. So they didn't know. What are your findings going to say? Was there sexual harassment? What are we missing? What do we need to be asking our poor male friend. Yeah, how has it affected his work life situation? So he comes to you and he says, you know what, this has been the most difficult team I've ever worked on. I find myself having anxiety attacks and having to pull my car over on the way to work. I've had to start medication. This has affected my relationship at home because my wife is hearing rumbling. She's on the PTA, our kid goes to that school, and she's heard these comments made. Do we have sexual harassment? Yes, absolutely. It's created a hostile environment for this individual. Does it matter that he wasn't the one that reported it? No. So we're going to issue our findings letter. What appropriate action are you looking at that point for that female employee? What may be necessary moving forward?
Your findings letter, by the way, or the findings letter from the investigator will say something along the lines of tracking DIA local. The evidence tends to show, because we're not going to deal with absolutes because we're not a police department, we're not FBI investigators. The evidence tends to show, or the overwhelming evidence shows, that this allegation of sexual harassment is sustained for the following reasons. So that's what it's going to say. Go ahead.
And the evidence standard is just more likely than not, 51% that it happened. We're not saying beyond a reasonable doubt this for sure happened. So we're not held to the criminal standard.
So in criminal law, there's a beyond a reasonable doubt standard, which is
It's your Matlock standard.
somewhere beyond 50%, probably a lot. There's no specific definition of what beyond a reasonable doubt means. In civil law, which we're dealing with here, it's 50% in the feather. So that's
No,
it.
it's that more likely than not that it happened. So you issue your findings letter. What action should be taken with this employee? This is where it sort of runs the gamut, right? So some people will say, reassign. That person should not work on that campus anymore. That's easy, okay.
Kelly will be involved.
Yep. Some people will say a firm reprimand and they'll never do it again. Some people will say they need to be terminated immediately. So when you're looking at that, again, we don't have a preference as to what that action is, as long as it's seemingly in line with the conduct. So you guys have consulted Kelly. Kelly knows how it's operated if you've had another example. So we're treating everybody equally. And then you're gonna make the best decision for the district.
Because our concern from the legal side, because Kelly knows the whole district, we know the legal side, we're going to be talking about, well, what do we do with our other employee that was under 40? What do we do with our other employee that was Baptist? What do we need to make sure we're neutral and non-discriminatory in all of our actions. So that findings letter that says evidence tends to show will be something that Kelly and us will be looking at and making decisions on based upon a whole different set of factors. But like we said earlier, the bottom legal line is we looked into it, we followed our policy, we investigated, we took interim action, we produced a report of findings. We did everything we needed to do to show, to prove in a documented action that we're not deliberately indifferent. So we've satisfied any sort of legal standard we need to.
And so we'll finish up with this piece because this is what usually gets people in the most trouble. Unwelcome advances. So you have two single employees. So the courts are not, they're not looking at this in a vacuum and saying sexual attraction at work doesn't happen. You're never going to meet somebody at work that you're sexually attracted to. So we have two single people. One of them believes that it's welcome. So they give overtures, they make, hey, you look great today, that sort of thing. The other person is like, oh, I feel really uncomfortable with this, I am not interested. But they never vocalize it. So we encourage individuals, if you're not into it, say, please stop. I don't know if you guys saw the Dallas Morning News article for the coaches in Plano. The coach said, I told her to stop repeatedly. And she didn't stop.
Do they know? Tell them.
It was the two basketball coaches, the assistant and the head coach. And I guess they had had some exchanges where the head coach had said, you're beautiful, or different various things. And the assistant coach says, stop. You need to stop. This is professional. We need to maintain professional relationships only. And that did not stop the other coach. And so that's when it crossed that line. When we look at it, how do we know if something was welcome? It's a case by case. We're going to look at all the evidence. So what we've seen turned over is text messages. So do they reply to the text messages? Are they engaging in the same dialogue in the text messages? That sort of thing. It's very case specific and fact specific. So we can't always say, okay, here you go. But if somebody has come out and said, no, stop, that's inappropriate, you better stop. And then previous relationships. This is what we see a lot in school districts. They've had a relationship at one point, the relationship is over, but the other person isn't aware that it's over. That's just the reality. They don't want it to be over, so they're not aware of it. And so they continue making comments about things that would have been okay when they were in a relationship that are no longer acceptable.
Is that a catfish? What is a catfish?
Oh my
Ghosting.
gosh.
Ghosting.
Yeah.
What's ghost? What's ghosting?
Oh my gosh. I'll explain it to you later. As you can tell, Chad doesn't watch a lot of TV.
I have a 3-year-old and a 5-year-old.
So he's not up to date. He had to ask somebody what airdrop on Mac was. So, victims have a right to be free from sexual harassment, whether they say stop or not. So, but the more obvious examples are when they say stop, when their complaints are contemporaneous, and it's clear. So when we look at all of that, just know the more we can encourage employees to speak up, to stand up for themselves, the better off we are in the long run.
And I'm sure you're thinking we're going to be doing reports and investigations all day, every day.
And it might spike after you train your folks.
And those reports of findings run the gamut. I mean, the bottom line is what we're trying to get across is in the world today, we need to investigate. We need to do that. The reports will be from the range of, 2 single people were talking and the single lady did not reciprocate the advances from the single guy, and she didn't like it, and finally he found out and was like, oh my gosh, I didn't know, I'll quit. Well, if we do the report and we do all the investigation, we get there, okay, adverse employment action is probably going to be maybe a letter of reprimand just saying don't talk about that stuff at work. That's it. But then we have the other side of things too that are really, really scary and really, really dangerous. We can't let the little ones slide by anymore as, oh, that's just kind of what happens, because over time we have found, not we, but the courts have found that those little ones are big ones in disguise. And so we need to find out what's the issue and what's going on. It's fine to do a report. It's fine to do an investigation. Every investigation doesn't end with a termination. They end most of the time with a directive. You're reassigned over here for this year. It's not always a termination. Sometimes they are, but we can't let those terrible, awful situations that are out there exist just because on the front end it looked like just 2 people saying off-color remarks. We need to find out if we know about it.
Are there any questions before we sort of walk away? Yes, ma'am.
So during the course of the investigation, you find that false claims, intentional trying to sabotage employee. What do you think?
We call that made in bad faith in the legal world. That's a bad faith allegation.
And if you have evidence to support that, which is just more than the suspicion, this person said, I'm going to get this person in trouble, which we've seen. It's rare, but we've seen it. Then that you need to be taking appropriate action towards the person that made the false report. Because that's just, people need to understand this is a serious allegation when you make it. And so don't make it just because you're mad at somebody. We've had it where employees break up and all of a sudden a sexual harassment claim is made because somebody felt treated unfairly after the relationship ended. and that was made in bad faith, and it's not usually obvious. So it has to be fairly obvious before you want to go around getting people in trouble for that reporting, but because you don't want to do anything that's going to stifle reporting.
There's most certainly adverse employment action related to a bad faith claim. Absolutely. And so that's something that we are seeing more and more of because of the attention that is paid to any sort of claim, any sort of allegation today. People see that. Bad actors see that, and they're like, oh my gosh, the school district or the college or whoever, they freak out anytime anyone says hostile work environment. They get all this investigation team together, there's policies involved, I don't even know what it all means, but they freak out. I really don't like that person. I think I'm going to get them that way. And so if we find that out during the course of our investigation, you better believe some real serious adverse employment action comes down the pipe. Like Becca says, it's important that we're able to prove it. It can't be on a whim, but that's one of those things, if you call me and ask me about it, I'll say, if we can prove it, we need to set a real darn clear precedent that stuff doesn't fly and take some real serious, as far as we can go, throw the book at them type legal or adverse employment action.
Any other questions?